Then we'll have our last panelist, Professor Frank Ravitch. Professor Ravitch is a law professor at Michigan State University. His career has included experience in private practice and on Capitol Hill. Since joining the Law College, he has authored several books and a number of law review articles, essays, book reviews, and book chapters, as well as amicus briefs to the U.S. Supreme Court. He is the author of Marketing and Creation, The Law and Intelligent Design, Law and Religion, a Reader, and in numerous other publications pertaining to law and religion. Currently, Professor Ravitch is working on a treatise titled Religion and the State in American Law. So without further ado, Professor Frank Ravitch.
Well, it's a pleasure to be here, and speaking after everyone else, a number of things have been covered that will make my talk a lot easier. But I am going to focus a decent bit, actually, on the proposed bill and the Michigan Legislature 4769. And I'm going to speak about that as a scholar of law and religion, also as a person of faith myself, and actually as a parent of children in Michigan. I'm obviously a Michigan resident, and there are many issues that the state confronts in these hard economic times, and the existence and resources spent on this bill for the reasons that I'm going to mention, I find highly disturbing when our school budgets are being cut. So I will mention that as well. But first let me talk about the bill and its relation to religious law. Given the panel so far, Christian law, Islamic law, and Jewish law, all of which I've had the pleasure of studying, and I spent a lot of time in Japan, I thought, well, maybe I'll just talk about Buddhist law. But what I'm actually going to talk about is concepts of religion in American law, and specifically related to this bill and the substance of this bill. So let me start out by saying that this bill, on its face, accomplishes virtually nothing. I am perplexed by this bill. I've commented publicly in the media and in newspapers on the Oklahoma bill. I think it is a repulsive bill, the Oklahoma bill, and similar bills like that. It's clearly motivated by anti-Islamic sentiments. It's also motivated by what I like to call legal xenophobia, which is a fear of foreign law, at a time when understandings of foreign law, I think, are economically very necessary for the United States. The Oklahoma law is repulsive, but at least you know what it does, right? It's clearly a discriminatory law that, under a doctrine in the U.S. Supreme Court that came from a case called Church of Lukumi Babaluai v. City of Hialeah, which said that laws cannot be passed that are intended to gerrymander or discriminate against particular religions. Given the history of the bill in Oklahoma and similar bills, it's clear that those laws would be unconstitutional because it's intentionally discriminatory. The legislative history there, the bill itself is an anti-Islamic bill. It's a horrible bill. I find it sickening. But you know what it does. This thing, I study law and religion for a living. I'm not good at anything else. It's the only thing in the world I'm like parenting. Those are the only two things in the world that I'm good at, and complaining when the New England Patriots lose. But other than that, and I read this thing over several times when Raheem sent it to me, and I came to two conclusions. One, that the bill either does absolutely nothing of legal significance, and I'll explain why. There are actually very good reasons for this. Or the bill does exactly what Professor Vischer suggested it does, in which case it is unconstitutional for a number of reasons that I'll discuss. So let's look at the bill first of all, and let me give you a suggestion as someone who's dealt with law and religion bills, everything from school prayer bills to intelligent design bills and things like that. This is frequently what you would call a stealth bill, right? This is a bill that is designed with a specific purpose, but it doesn't state that purpose. And we see this a lot with bills relating to religion, in things like school prayer and intelligent design and things like that. The reason is to try to avoid an establishment clause violation. This bill, I think, is a stealth bill because of the fact that, as was originally mentioned, 40 people signed on to it because they didn't really know what it was really about. And this stealth bill, I think, is designed to make a point I guess I would say, it was going to be my conclusion, but I'll say it now. At best, this bill seems an attempt to win political favor. Some might call it pandering. But getting signatures on the bill is helpful. And if the bill on its face said what the Oklahoma bill said, this is an anti-Islamic bill, then I think that it would be harder, even in the current political climate, where divisiveness on both sides tends to be a favored tool. I don't think very many people would have signed off on it. So this is a stealth bill, and in a way no different from stealth school prayer bills and other stealth bills that are dealing with religion. And the idea that, you want to cut the conversation short, talk about religion and politics. This is religion in politics, so hide it. Hide it and get support for it. So now let's look at the provisions of the bill. The bill seems to try to do three things. One is, it seems to be saying that Michigan courts and authorized administrative panels and authorized arbitration panels and so forth are not able to enforce foreign laws, i.e. Islamic, potentially Jewish, and foreign, I guess, laws of foreign nations that violate constitutional rights. They can't do that anyway. There's one thing if you're saying, and this was what the Oklahoma bill tried to do, is you can't even use these laws, right? This law is saying if it violates a constitutional right, you can't enforce it. If it violates a constitutional right, you can't enforce it. You don't need Bill 4769. Okay, so to the extent it's telling courts, by the way, don't do anything unconstitutional, okay, that's wonderful, and I'm glad you put it in a bill that does absolutely nothing else, but why are you wasting my children's time and money with this? So what are the other two things that the bill does? I'm going to come back to the contract provisions in a moment, because I think that's the most significant element of it. There is also a jurisdictional element of the bill, which says that courts shall not allow matters to be removed to other jurisdictions. That suggests foreign nations, couched based on what the proponent of the bill suggested, as nations with Islamic law, but I assume it would apply to France as well. When the removal to those jurisdictions would violate the constitutional rights of an individual. And there's two points here. One, courts can't do that anyway. If you're going to recognize another jurisdiction that will violate a constitutional right, even if it's in a contract, that jurisdiction will have the ability to determine the outcome of a case. Courts will not remove it. And there are many examples of this. You cannot contract, Rob made the point, you cannot contract to be sold into slavery. That also means you can't contract to be sold into slavery in another country, and if the contract is going to violate that constitutional right, a court's not going to recognize the contractual provision in another jurisdiction. Now, to the extent that it might be saying, and this relates to the contract provisions, that the law will not allow unconstitutional contract provisions to be enforced by a court. I'm still scratching my, if I had hair, I'd really still be scratching my head. I'm still scratching my head about this. What the heck does this mean? What the heck does this do? Because there's really only a couple of possibilities here. And it relates to the jurisdictional element, because I think really what the jurisdictional part of the law is saying is you can't contract to have your matter removed to another jurisdiction if it would violate constitutional rights. So I think that's really subsumed in the contract provision. But this deals with things like marriage contracts, which you've already heard are central in halakha and sharia. And the contract provisions, I don't understand. Okay, constitutional rights are vis-a-vis government. Okay? It is a fundamental aspect of constitutional law that state action is required. Okay? For something to be unconstitutional, there must be state action. Now, obviously, a court getting involved is state action, But that's not what the law is talking about if the contract provision violates a constitutional right. But if the contract is between private parties, how can a contract provision violate a constitutional right? The only possibility that I could come up with, and it's extremely troubling, and it's an incredible slippery slope, which all three speakers have already spoken of, have already touched on, which is that perhaps the meaning of this provision is that were the government to have contracted, or were the government to if the government was the entity that was doing whatever will be done under this contract, it would be unconstitutional, and therefore courts cannot enforce it. So if private parties contract to do something with each other that government couldn't do to either party, that the courts will not enforce this. I find this incredibly troubling because, as has been pointed out, private parties routinely contract to do things that government could not do to them. It's a constant in all sorts of private contracts. And then when Professor Fisher was speaking, these Christian arbitration agreements, it occurred to me that, what do we mean by foreign law? To the extent that these things fall under some sort of Christian conception of law, isn't that a foreign law? So isn't this bill going to ban the Promise Keepers from holding people to binding contracts? There's also an entire area of law and religion that deals with the enforceability of wills and trusts and religious contracts, whether or not you can have a charitable gift enforced by a religious entity. With this law, and there's in most states, including Michigan, there's an exception for charitable devices that you don't need consideration. You don't need a bargain for exchange in the traditional sense. Many of these devices are based on religious law or conceptions of religion. If that's foreign law, does that mean now that these devices cannot be enforced and everything from a Protestant church to an Islamic community center cannot get its bequest? Because to do that would enforce foreign law, and of course government might not agree to some of the terms that would exist in these contracts, or government might not be able to enforce some of these terms that are in the contract. So there's two possibilities here. One, and I think it's the more likely possibility, is the law accomplishes nothing because contracts are between private parties, therefore provisions in the contract are not going to be unconstitutional, and the bill doesn't accomplish anything. The other possibility is that the bill essentially makes all law that is not American common or civil or constitutional law, in essence, foreign law, all other legal systems, including religious legal systems, which would technically not be limited to Islam and Judaism. We can talk, those of you interested in Buddhist law, we can talk about Vinaya and how that could come into play as well. But the reality is that if that is the case, I don't think the proponents of this bill have really thought about it, because they may want to talk to their own ministers, which I'm assuming they based on some of the talks given on the Hill that they may have, they may want to go talk to those ministers and pastors and maybe advise them, I'm really sorry, but the charitable bequest that you were expecting for $100,000, given the fact that government couldn't enforce it against a non, if it was given to a non-religious or non-charitable entity, sorry, we're not going to get that money. Now, there's another possibility here, which is, to me, if this is the case, so brazenly unconstitutional that it's not only a waste of time and money. If the law passed, I will help whoever wants to challenge it, and then it will, I think also waste administrative time in the courts, and because it would be clearly unconstitutional, and that's that they're only applying it to foreign legal systems, which then they would say that includes Sharia. They may not realize it, but it would also include halakha, which is very much a legal system, and that it doesn't include, Christian law, though I would assume it would include Catholic canon law. And Eastern Orthodox canon law. I can't wait till the drafters of the bill want to go talk to some folks around Detroit about, invalidating anything involving Catholic canon law and Eastern Orthodox law. But that aside, it may mean that it doesn't really apply to Protestant conceptions of law, which may be less legalistic in a formal sense. Well, if that's the case, then it's clearly what everybody thinks it is, and it's a violation of the Establishment Clause, because now you're picking which religious law is favored. And even if it's not a violation of the Establishment Clause, there might be an argument under this case I mentioned, Church of Lukumi Babalui, that because of the way the law was designed, and certainly given some of the testimony in favor of the law, that the reality is that it would possibly be a case of religious gerrymandering. One final note on this, on the bill itself, and that is there is something called the ecclesiastical abstention doctrine. It's somewhat controversial, it's very big and very broad, but the idea is that courts can't get involved, civil courts, Michigan courts, federal courts, any state courts, cannot get involved in determining ecclesiastical matters that involve religious law. One of the problems when you're dealing with a law that says if a provision of one of these contracts or jurisdiction removal provisions, whatever, is unconstitutional or would violate constitutional rights, it cannot be enforced by a court, is frequently these provisions are not clear. I mean, some of them are clear, but a lot of them are going to require interpretation. But how can a court interpret the meaning of a religious provision without making ecclesiastical decisions? So in order to determine whether or not the legal provision violates a constitutional right, the court may have to violate the Establishment Clause, because it would be involved in ecclesiastical decision-making. And again, I think all of this is hypothetical, because I don't think the law even does that. I think it's simply the contract provision is moot, because there's no such thing as an unconstitutional private contract. Now, there are illegal private contracts. Several people mentioned, Rob mentioned legally that you can't enforce a contract by duress and things like that. That's true whether it's a religious contract or a non-religious contract. And obviously in Sharia and Halakha, those of you who have studied Sharia and Halakha, you know, and those of you who haven't, I will tell you, contracts under duress are not recognized under either Islamic or Jewish law. And in fact, both Islamic and Jewish law have very well-established systems of due process. I found it very interesting, the notion, people about cutting off hands, because one of the things I teach my students when I teach Sharia is that, there's so much due process that penalty has not been enforced other than in the most radical regimes for hundreds of years. And even back then it was controversial. In Jewish law, technically there was the death penalty, but there was this Sanhedrin, Jewish high court called the Bloody Sanhedrin. It was called the Bloody Sanhedrin because over about 100 years, one person was executed. There's so much due process involved in these areas of law. And when you look at the contract provision element of this law, I'm perplexed. I mean, as a law professor, I am perplexed. What the heck does this do? Because two choices: either it does something brazenly unconstitutional, or it does nothing. And if it does nothing, then this law as a whole does nothing. And this is where I want to point out that as a Michigan citizen, and as a parent, and as a nonpartisan, sorry, I don't like either side. As a nonpartisan, I am appalled. I am sickened by this. My children's school just had a budget cut that we are feeling heavily. They're removing important classes. And our school district's faring better than most because we planned better. And I am appalled that one staple, one piece of paper, legislators' time was wasted on this. This is a chance to pander. And I don't care. I mean, I'm not trying to pick on anybody. I don't like pandering no matter what side it comes from. Because I like my kids. I love my kids. And I love my state. And I love when my state actually has money and resources so that people can have jobs. Where the heck are these legislators that are proposing this? Why take the time to do this instead of doing a jobs bill? Or, I don't know, anything. I don't care whether you're Republican, Democrat. Do it whatever way you want. Okay, I don't care what your position is. I mean, find a way to help people. This bill helps no one. This bill does nothing. To the extent that this bill does anything, it's most likely unconstitutional. And as a Michigan parent, and as a person of faith, and as a citizen, I can't even tell you, when Raheem sent me this bill and I read it, I was expecting the Oklahoma bill. So I was expecting to be appalled and upset and, you know, and for the reasons of discrimination. When I read this bill, I was appalled and upset for the reasons of wasted time and energy. We have bigger problems in this state. Much bigger problems. And I don't even know what to say about that. One final note, and then I'm gonna close. And this is on something that was mentioned on the belief-practice dichotomy, belief and practice. And Rob is absolutely right. Professor Vischer, sorry, we've known each other for a long time. Professor Vischer is absolutely right when he says that much of the American legal view of religious belief and practice is based on sort of Protestant conceptions, and not even all. I mean, there's huge diversity within the Protestant denominations, but concepts of belief being not the only thing. I mean, most Protestant denominations, actions do matter, but belief is the most important thing. Islam and Judaism, Buddhism, numerous other religions within Christianity, Seventh-day Adventism, practice and belief are not separable. The U.S. Supreme Court has treated it that way periodically, and today, in fact. But you cannot have belief in Judaism, which is my religion, or Islam, or Buddhism without practice. The two are intertwined. You show your love for God by what you do. Okay, that is true in Islam, that is true in Judaism, that is true in many religions. In Buddhism, you show your love for the world through what you do. But a bill that wants to separate that out, and I don't think this bill accomplishes that if it's what it wants to do, is highly problematic because it feeds into a notion of religion, and I'll just quote Professor Vischer here, that is just, well, you use brazenly, but brazenly naive. It is a very poor understanding of religion. And I think that's because this bill is based in anti-Islamic sentiment. I find that to be repulsive. My people have been victims of this. So to see another group be a victim of this makes me want to cry. But this is a stealth bill, and so it doesn't show that way on its face. And it's important for people to get the word out about that. And I do want to point out that, and Raheem mentioned this in the beginning, and this is what I'm going to close with. Eventually, they will come for you, whoever wrote this bill. It's only a matter of time. Okay, demographics change. Demographics shift. And there are places in the world today where evangelical Protestants are being persecuted. Why would people who share, whether it's evangelical Protestantism or some other faith or some other notion of faith, why would you want to do that here in a land of religious liberty? Why would you want to pick out a group that has a rich history and is not monolithic and impose will on that group? And by the way, through the side door, impose will on the Catholic Church, Eastern Orthodox churches, and Judaism. I don't for a second believe that this bill was aimed at those groups. And so I find it very troubling as a law and religion scholar, as a parent, as a Michigan citizen, and quite honestly, as a human being. I don't know what the purpose of this bill is, and I've read it 15 times. So that's my testimony. I'm sorry to be so negative, but I like to usually have something to work with. So I could say, well, I understand what they're trying to do. I don't have it. There's nothing. Got nothing. Thank you.